Hello, everyone, and thank you for joining us today for Visa Nation's monthly webinar. We're excited to dive into the H-1B lottery process and explore the changes to expect under the Trump administration. At Visa Nation, we are dedicated to providing reliable expert immigration guidance to our corporate clients and have over a decade-long track record of success. With a team of experienced professionals, we stay ahead of industry trends to offer personalized advice, ensuring that our clients' immigration needs are handled with care. I don't know if everyone can hear. Sorry about that, everyone. To further enhance our services, we utilize our own custom software to streamline and automate the immigration process, ensuring efficiency and accuracy at every step. Whether you're an individual or a business, Visa Nation is committed to delivering innovative solutions tailored to your unique situation. We're honored to have three distinguished speakers with us today. We welcome Managing Attorney Shilpa Malik, Attorney Brian Tomto, and Attorney Katiana Quindamil. Together, they offer a wealth of experience in handling complex immigration cases for corporations of all sizes. Please feel free to ask questions in the chat directly on LinkedIn or YouTube, and we'll do our best to address all of them. Please do not include anything that is confidential to your case. Now welcoming Attorney Shilpa Malik.
Hi, good afternoon, everyone. It's such a pleasure to be here today and discuss some of the nuances of the H-1B lottery that is about to start in less than 2 weeks, as Nirmala introduced us all. And thank you, Nirmala, for that. We appreciate it. We are a team of highly experienced professionals who are here to address your questions about H-1B. This webinar is strictly for H-1B related questions and comments only. So please keep that in mind when you post any questions for us to consider. So without further ado, I would like to get started so I can get as much material covered as possible. At this time, we're going to talk about our agenda. The first point we'll discuss is the H-1B registration process. Then what are the new changes you can expect in 2025? What are the expected fees for this year's lottery and subsequent filings of the H-1B if one is selected in the lottery? And our final part will be a Q&A session. We do have a couple of bonus details that we'll be sharing with you, which include Cap-exempt H-1B, which obviously may be of interest to some of you. And one of the bigger changes that USCIS brought about this year, which is Owner-beneficiary H-1B filings, which is a big deal for a lot of entrepreneurs, and it's super exciting to pursue. And USCIS is, in fact, encouraging bona fide entrepreneurs and business owners to explore that opportunity. And I would encourage qualified applicants to look deeper into it to see if that's a possibility for them. So we can move on to the next slide, which talks about H-1B deadlines for 2025. Please remember, any H-1B that's filed only kicks in on October 1. So technically, it's for the FY 2026, which is the fiscal year 2026. The fiscal year for USCIS starts on October 1 each year. The H-1B registration starts on March 4th at 12 noon Eastern Standard Time and ends on March 24th at 12 noon Eastern Standard Time. If there are technical issues, USCIS may possibly extend the deadline, but nobody should count on that. And please ensure that your registrations are properly submitted in this 2-week window. It's very critical to adhere to these deadlines and to properly submit your registration. USCIS will then conduct a computer-generated lottery, which is completely random. It does not consider the merits of any submission. It's based on the beneficiary's passport number. That is the identifying factor, and we expect the results to be released anywhere between the 27th of March all the way until 31st of March. So if a person is selected in the lottery, their employer will receive notification from USCIS, as will their attorney, should there be an attorney involved, indicating that an action has been taken on the registration, which generally means that the registration has been selected in the lottery. If no communication is received from USCIS, that means the registration was not picked in that particular lottery. I do want you to remember that USCIS has 65,000 visa numbers allocated under the regular cap, which is for bachelor's degree holders from the United States as well as anywhere else in the world. And an additional 20,000 are strictly reserved for master's degree holders from a qualified U.S. institution only. So master's degrees from overseas will not count towards the master's quota. If the registrations that are selected in the lottery, once the employer is aware of that, they will go ahead and have an opportunity to submit a full-fledged H-1B petition between April 1 and June 30th. It's a 90-day window in which a full application has to be submitted to USCIS. Now, please remember, USCIS has increased the fees this year for the registration, so we're hoping that there'll be a drop in the number of applicants and only serious registrations will be submitted. But again, H-1B is one of the most popular visa categories at this time. And therefore, there still could be a significant number of registrations that are submitted to the lottery. And your chances always depend on how many registrations are actually submitted in that 2-week window. Historically, it's been 1 in 5 or 1 in 6 in terms of selection. This year, it could be the same, it could be less, it could be more. We wouldn't know until USCIS announces the data subsequently. Now we can move on to the next slide, which will talk about what are the possible chances of experiencing increased scrutiny under the Trump administration. For that, I would like to invite my colleague, Attorney Brian Domto, on the screen. He'll be sharing some very important insights with you about this, so please pay close attention to this. Thank you.
Thank you, Shilpa. Yes, so Shilpa went over the lottery requirements. So now I'll talk about what happens when your case is selected in the lottery. So the big thing that we're anticipating is increased scrutiny for H-1B petitions. As you can see on this slide, in 2017, under the first Trump administration, we saw increased requests for evidence and also an increase in H-1B denial rates. A lot of this was pertaining to the requirements for specialty occupation and also employer-employee relationship for cases where they are placed at an end client site. So by tightening requirements for specialty occupation, what do we mean here? So basically, the areas that we're anticipating increased scrutiny is clarification on the degree requirement for H-1B. So H-1B requires that if you can move to the next slide, requires that a person have a U.S. bachelor's degree in a specific specialty related to their occupation. So that means that there's going to be increased scrutiny for professions such as software developer, computer programmer, that have multiple disciplines for academic degrees may get increased scrutiny. So if you look at the 4 criteria, you need to meet at least one of these 4 criteria for H-1B. As I mentioned, the specific degree to the specialty, and that it's normally required for the employer's industry, and that basically that if you are at a third-party site, that it's required for that company as well for that position. So basically the breakdown is the education field must have a logical connection between the degree and the requirements to perform the job duty. So what do we need to do for this? Employers will need to define their job roles more specifically to what the education is required for each individual job duty listed on the H-1B support letter. And they'll have to maintain documents as well to show on a potential request for evidence that these are industry standards, that they're internal standards for people in similar positions, that they require bachelor's degrees in these fields to perform these job duties. In addition, the employer will need to show that there's a bona fide job offer to the H-1B employee. The employer may need to show additional evidence to show availability of work. This could lead to some shorter approval periods if the work that the employer can document shows contracts, work orders that are going to be completed on specific dates. So that is something to keep in mind. And with that, I will pass on to Katiana, who who will explain H-1B Cap-exempt.
My apologies. Appears I was on mute. Can everybody hear me? I believe so. Okay. Good afternoon. My name is Katiana Kundinmo. I'm an associate attorney here at Visa Nation, and I'm going to be discussing the changes that were brought about in relation to H-1B cap-exempt employers. So normally speaking, H-1B cap-exempt employers can petition for an H-1B employee without going through the normal lottery process. And essentially, they can be approved at any time, at any part of the year, because they're not subject to the limits on the lottery cap. Now, generally speaking, there are 4 types of employers who are normally considered cap-exempt employers: institutions of higher education, nonprofit colleges or universities, nonprofit organizations that are affiliated with institutions of higher education through a written affiliation agreement and an active working relationship, government research organizations, and nonprofit research organizations. Now, under the Trump administration, with the H-1B modernization rule, there's been updates to the regulations governing what's considered an H-1B cap-exempt petition. Now, the H-1B modernization rule expands the definition of cap-exempt employers who can solicit for H-1B visas outside of the visa cap. One of the main things is it revises the definition of what's considered a nonprofit research organization and a governmental research organization. Now, this also includes organizations that conduct research as a fundamental activity, but it does not need to be the organization's principal or foremost activity. This change in language is aimed in allowing more institutions engaging in research to sponsor H-1B temporary workers outside of the visa cap. This new rule also provides clarification on what it means to work at a qualifying cap-exempt organization. Now, work performed at qualifying cap-exempt employers also can include work performed remotely, via telework, or offsite. In addition, certain beneficiaries may qualify for the H-1B cap exemption when they're not directly employed by a qualifying organization, but instead spend at least half of their time providing essential work that supports or advances the fundamental research activity of the qualifying organization. The modernization rule also further clarifies that in order to qualify for the American Competitiveness and Workforce Improvement Act fee exemption, otherwise known as the ACWIA fee exemption, a nonprofit must have the IRS tax-exempt designation under the 501c3, C4, or C6 in order to qualify. In addition, the rule eliminates the additional requirement previously imposed that they had to have been approved for tax-exempt status for research or educational purposes. So with this new exemption, with the modernization of the H-1B, it is expanding what is considered cap-exempt employers and allowing for more ability for individuals who are working, spending most of their time providing services for this qualifying employer to possibly not be subject to the cap. But again, this is on a case-by-case basis and should be discussed with your attorney if at the time of filing. Now, I would like to shift it back to Shilpa for a discussion on the owner-beneficiary H-1B filings.
Thank you, Katiana. I really appreciate it, and that was very helpful. Thanks for sharing your insights on that. Before I go into the owner beneficiaries, I did want to add something important here that Brian did go over some of the requirements for an H-1B specialty occupation. I do want to invite the employers and the employees to consider that the USCIS is going to tighten the requirement of having a degree in a specific field, which means there has to be a very strong nexus between the degree that the beneficiary possesses and the position that the employer has for the beneficiary. And it has to be a specialty occupation, which means there's at least a minimum requirement of a bachelor's degree in a particular field for the beneficiary to perform those job duties. USCIS is going to frown upon general degrees such as a business administration degree with no specialization or an MBA, so please keep those things in mind. Other than that, if the evidence is there, the documents are there, the H-1B will get approved. So there's no reason to develop any kind of fear in this matter. It's just a matter of making sure that we present the right kind of evidence at the outset to possibly reduce the chances of getting a request for evidence, because those things can take extra money and time to respond to. So please be very careful with your submissions. For those who are obviously lucky enough to get selected in the lottery and are supported by your employers. Nirmala, if you could just switch to the fee slide, I'll go over that very quickly for the benefit of our viewers and listeners. The registration fee this year has gone up to $215 from the $10 fee that was payable last year. Premium processing as of last year is $2,805. Either the employer or the employee can pay it. There is a public law fee if more than 50 plus employees are on H-1B or L-1 status, which is usually not very common, but yes, it is a significant fee payable, but does not apply to all employers. The basic filing fee is either $780 or $460, depending on the number of full-time employees an employer has in the United States. There's an ACWIA training fee, which is $1,500 for employers with more than 25 full-time employees and $750 for employers with 26 or more full-time employees. USCIS did introduce an asylum program fee as of last year, which is mandatory for all employment-based filings. It's $600 for employers with more than 25 full-time employees and $300 for those with less than 25 full-time employees. And the attorney fee, of course, varies from firm to firm, something to just keep in mind. Now, I can jump on to the last bonus addition to this webinar, which talks about H-1B owner-beneficiary rule, which to me is an extremely important development and extremely exciting, because it gives people who are involved in legitimate startups or who are entrepreneurs who intend to bring their great ideas to the United States to benefit the U.S., an opportunity to file for their own H-1B if they're a majority owner of an entity in the U.S. This was introduced as of January 17, 2025. So if the owner beneficiary has more than 50% interest in the company, they can have the company, which is considered an individual or independent entity from the owner, the individual owner, to file for their H-1B. This allows entrepreneurs and startup founders to serve both as the petitioning employer and the beneficiary. So this is a very interesting development, because there was this factor of employer-employee relationship, which is very critical to H-1B filings. But in this case, USCIS acknowledges that being an owner is independent of being the entity that's sponsoring you. So please take use of this opportunity if you believe that you qualify and have a legitimate business in the United States that would benefit from you getting an H-1B as an owner beneficiary. Again, the specialty occupation requirement remains, which means the position for which your H-1B is being sponsored by your own company has to be a very specific occupation for which at least a bachelor's degree in a particular field is needed. This is not there's no exception to that. You may perform some duties towards owning and developing your company, but a majority of your job duties have to relate to a position that has a nexus to the degree that you possess. You have to comply with the labor condition applications, which means the company has to pay you the wages that are listed by the Department of Labor as the prevailing wage for that particular position. Therefore, that is also an extremely important requirement, and USCIS will closely look at it by seeing what is the potential for your company to generate business, revenue, etc., to be able to pay your salary. There is no exception to that. There's nothing like, okay, I will have my I will basically put all my money back into the company. I'm not going to take a salary. That is not an option. You need to be paid a salary as any other employee. Now, one important thing to remember is owner beneficiary H-1Bs, if approved, will be approved for an initial period of 18 months only, as compared to the 3 years that are allowed for other H-1Bs, because USCIS wants to take an opportunity to determine how this plays out